Imagine you're relaxing at home when there's a knock at the front door. You open it and find two police officers standing outside. They tell you they're there to ask a few questions, and one of them casually says something like, "You don't need a lawyer for this." It sounds friendly. It sounds harmless. But what happens in the next few minutes can determine whether this ends as a quick conversation or turns into a much larger investigation. The natural reaction for most people is to cooperate. You think, I've done nothing wrong, so why would I need a lawyer? That's exactly why this tactic can be so effective. The problem isn't necessarily the officer's question. The problem is what happens when you start talking. Before you understand where the conversation is going and how your words can later be interpreted, police officers ask questions because answers can become evidence. They may already have information, or they may simply be trying to figure out where an investigation should go next. Your own words can provide details, contradictions, timelines, explanations, or admissions that officers didn't have before they arrived. And once you've given them that information, you can't simply take it back. That's why the first thing to understand is this. You should not assume that being innocent means you need to answer every question. Innocent people can misremember dates, confuse details, misunderstand questions, or explain something poorly under pressure. Now, what feels like a harmless conversation can later be written down in a police report in a very different way. Imagine an officer asks what you were doing yesterday afternoon. You answer quickly and give an approximate time. 10 minutes later, the officer asks again, and you remember a different detail. That may be completely normal human memory, but now an investigator can compare the two answers and decide that you changed your story. A small difference can suddenly become inconsistent statements or evasive behavior. And that is why the phrase, "I have nothing to hide," can be much more dangerous than people realize. It sounds like something an innocent person would say, but legally, it doesn't protect you. It doesn't stop questioning. It can actually encourage you to keep talking and give investigators more information than they otherwise would have. So what happens when you realize you don't want to answer questions? A lot of people make another mistake. They say something like, "Can I have a lawyer?" Or "Should I talk to a lawyer?" That sounds like a request for counsel, but the Supreme Court has distinguished between a clear invocation of the right to counsel and an ambiguous or conditional question. In Davis v. United States, the Supreme Court held that an ambiguous or equivocal request for an attorney did not require police to stop questioning. The case involved language along the lines of, "Maybe I should talk to a lawyer." The court said that wasn't clear enough to require questioning to stop. The lesson is simple. If you want to invoke your right to counsel, don't turn it into a question. Another mistake is assuming that silence by itself will automatically communicate that you don't want to talk. That's not always enough. In Berghuis v. Thompkins, the Supreme Court held that simply remaining silent for a long period did not, by itself, clearly invoke the right to remain silent. The court's reasoning makes an important practical point. If you want to exercise the right, say so clearly. So now you've got 3 situations to avoid. Don't volunteer a long explanation because you think innocence requires it. Don't phrase your request for a lawyer as a question. And don't assume that sitting silently without clearly invoking your rights will necessarily stop the conversation. This is where Edwards v. Arizona becomes extremely important. The Supreme Court held that when a suspect clearly invokes the right to counsel, police interrogation must stop until counsel is made available, subject to the legal rules governing such a situation. The key word is clear. So instead of saying, "Can I get a lawyer?" or "Maybe I should talk to someone," use direct language. You could say, "I'm invoking my right to an attorney. I will not answer questions without my lawyer present." That's clear, direct, and leaves much less room for anyone to argue that you were simply thinking out loud. Then comes the hardest part. Stop talking. A lot of people get the first sentence right, and then immediately ruin it by continuing the conversation. They say they want a lawyer, and then start chatting about something unrelated. Maybe an officer starts talking about sports. Maybe they ask how your day is going. Maybe they make a joke. Maybe they say, "We're just waiting for the paperwork anyway." Don't fall into the idea that a friendly conversation is legally harmless. If you have clearly invoked your right to counsel, the safest approach is to remain quiet and wait for legal counsel rather than reopening the conversation yourself. Police may also try a different tactic. Making you feel like invoking your rights makes you look guilty. You may hear something like, "Why do you need a lawyer if you didn't do anything?" Or, "If you're innocent, just tell us what happened." This can be persuasive because most ordinary people want to appear cooperative. But exercising a constitutional right is not proof of guilt. You don't need to prove your innocence by talking to the person investigating you. You can remain respectful while declining to answer questions until you've spoken with counsel. Another common tactic is creating a sense of urgency. An officer may tell you, "This is your last chance to tell us your side." Or they may say, "We already spoke to the other person and we know what happened." The goal is to make you believe that silence will hurt you more than talking. You don't know what information the officer actually has. You don't know whether the statement about another witness is accurate, and you don't know whether your explanation will help or simply give investigators another detail to test against other evidence. Then there is the promise. An officer might say, "If you just cooperate, I'll talk to the prosecutor," or "Help us out and I'll see what I can do for you." Be careful with statements like that. A police officer's suggestion about what might happen later is not necessarily a binding promise from a prosecutor or court. The person standing at your door is not necessarily the person who has authority to make charging or plea decisions. Don't trade away your silence based on a promise you cannot enforce. There is also an important difference between being polite and being cooperative in the legal sense. You can be respectful without answering substantive questions. You can say, "Officer, I understand what you're asking, but I'm not answering questions until I've spoken with an attorney." You don't need to argue with the officer or accuse them of wrongdoing. And you don't need to explain why you want a lawyer. The clearer and shorter your response, the less likely you are to create additional confusion. Let's go back to that moment at the front door. An officer says, "We're just here to ask a few questions. You don't need a lawyer." The easiest mistake would be opening the door and immediately starting to explain everything. A safer approach is to remain calm, listen, and avoid volunteering information. If you don't want to answer questions, clearly invoke your rights. If you're asking for counsel, make the request direct and unambiguous. Then stop discussing the substance of the investigation. That doesn't mean you should become hostile. It doesn't mean you should slam the door in an officer's face. It means you should understand that cooperation and consent are choices, not automatic obligations, simply because someone is wearing a badge. And if police are asking to come inside your home, remember that there is another separate issue: entry and search. A request for an interview doesn't automatically mean you have to invite officers inside. If they claim they have a warrant or some other legal authority, the circumstances become different, and you should avoid physically interfering with lawful police action. But you can still make your position clear. I do not consent to a search. Then, if they claim to have a warrant, ask to see it and speak with counsel as soon as possible. The bigger lesson here is that police questioning isn't necessarily a conversation where both sides are simply trying to exchange information. Investigators may have a goal. They may be testing your story. They may already have evidence and want to see how you respond. Or they may be trying to develop the first meaningful piece of evidence they have. That's why your words matter. Your memory may be imperfect. Your wording may be misunderstood. Your nervous reaction may be interpreted as suspicious. And once you start answering questions, you may not realize which sentence becomes important later. That's why people should stop thinking of the right to counsel as something you use only when you've been formally arrested. The circumstances matter, and the precise legal rules depend on the situation, but waiting until a conversation becomes obviously dangerous can be too late to avoid unnecessary problems. You don't need to know every Supreme Court case when someone knocks on your door. You need to remember a few basic principles. Don't assume innocence requires you to answer every question. Don't turn a request for a lawyer into a question like, "Can I have one?" Don't rely on silence alone if you're trying to clearly invoke a constitutional right. And once you've clearly invoked your right to counsel, don't undermine that decision by continuing to have a casual conversation about the investigation. Stay calm, be respectful, be clear, and stop talking. Because sometimes the most damaging thing you can give an investigation isn't something police discovered on their own. It's something you handed them voluntarily because you thought explaining yourself would make everything easier. And if an officer tells you you don't need a lawyer, don't automatically accept that statement as advice about what is best for you. The officer's job and your interests are not necessarily the same. Your job is to protect yourself, understand your rights, and make decisions deliberately rather than under pressure. There's one final point you should remember. This isn't about treating every police officer like an enemy. It's about recognizing that questioning is part of an investigation, and you should not assume that being friendly means the conversation has no legal consequences. You can cooperate with lawful instructions while still declining to answer investigative questions until you've spoken with an attorney. If you ever find yourself facing a serious investigation, getting advice from a qualified lawyer who knows the law in your jurisdiction is far safer than relying on a roadside conversation or something you heard online. Because when police show up asking questions, the first thing they may be looking for isn't evidence sitting somewhere in your house. It may be the evidence coming directly out of your mouth. And once you've said it, you can't unsay it. So remember the simple rule. If you want a lawyer, be clear. Say, "I'm invoking my right to an attorney. I will not answer questions without my lawyer present." Then stop talking. And there's another situation you should be prepared for. What if police don't come asking about a crime at all? What if they show up at your front door and say they want to see your firearms? That's the next situation we'll break down, including what you should say, what you should avoid doing, and how to protect your rights without escalating the encounter.